Morning all. We're here for day one of the trial in the matter CFI 16, 2015. Excellency Justice Ali AlMadhani is by telephone representing himself. The defendant is represented by Helene Matthew Legal Consultants. Lead counsel is Daniel Rusin, assisted by
Good morning. Morning all. Well, how we come to the hearing finally? Maybe it's not in the perfect way, but at least we are at the hearing now. Yes, Mr. Rusin, I think you have some of housekeeping matters if you would like to address.
Thank you, Your Excellency. As mentioned in an email sent to parties earlier, we wish to present two opening applications. First one relates...
Are you presenting applications first, okay?
Yes.
Tell me.
First one is related to the fact that the status of the file, where pursuant to why it should be stricken or dismissed right at start. The second one would be related to having this hearing be private. Public is not light of the allegations and one witness statements that.
Okay, let's start with the second one, the privacy.
Okay. I
prefer to start with the privacy first, if you don't mind.
No, I don't mind. I'm available to the court to. Your Excellency, the general rule according to 35(2) of the rules that application for all the hearings should be public.
Yes.
But at 35.4, a hearing or any part of it may be in private if, and then subparagraph 1, publicity would defeat the object of the hearing. Paragraph 3 involves confidential information. Publicity would damage that confidentiality. As you know, my client, which is 5 minutes away from here, is one of the members of the royal family. Now, light of the witness statement of Mr. Buhair, especially paragraph 32, or base documentation to support it, the kind of intervention that we wish.
No, I don't see where is the confidential information that need to be protected.
Well, basically, it's the for my client, for his reputation, Your Honor. There are some allegations, and as you've seen, the claimant had another chance to file witness statements. They choose to come again at 95% of the witness statement of Mr. Buhair pertains to the judgment of Justice I hope I'm pronouncing it right. Is it Gillis or Giles?
Giles, yes.
Giles, I'm sorry. Giles, Justice Giles, where it struck out everything concerning slander and everything concerning mismanagement. Now the claimant is coming back with a witness statement from Mr. Buhair.
Well, Mr. Rusin, I'm aware of this. Our concentration in the hearing, and again, it's also your cross-examining. The witness doesn't have to say anything. He's going to respond to your question only. And then if you keep your question, okay, if you keep your question in the scale of the sale and purchase of the stocks,
yes,
and then the consideration of the stocks, then we have no problem. We didn't have to cross the defamation or any area that Roger Giles had struck out already.
This I will certainly do. I will not go there. That is for sure.
Then the witness is not going to repeat what he said in his witness statement because it's before all of us. He would be only responding for your question, cross-examination.
I'm fine with the fact that the court will limit all this hearing to the question of the share sale and share transfer.
This is my understanding, yes. I'm aware of the Justice Giles' judgment, and I know what's the case about. It's about the purchase of the shares only.
Okay, so in light of this, if the court intends not to go wider than that, like I said, it's a question of supporting the allegations which are unsupported, and we didn't want for everybody or journalists. Last time when we were before Justice Giles, there were a couple of journalists that were there.
Yeah, because, okay, that day you were discussing the defamation and other things, you know, but today we have a very concise case. We know what we're talking about. We have only one point to discuss here, is the price of the shares only. So I guess there is no room for a privacy application. So your application for confidential or private hearing is dismissed. You may move to the second application.
Yes, the second application relates, and it's at length discussed in our skeleton that was presented. In light of the fact that the case has been partly settled, well, not settled, but disposed of by the court, we're just here for the question of the share transfer. Now, the claimant is a company. It's not Mr. Abu AlHaj personally. So at this point, we're just talking about the company claiming some money from my client.
No, we have two claimants now.
No, there's only one.
On the case, if you see even your skeleton, you're addressing two claimants.
Yes, but
Mohammad Abu AlHaj, then Abu AlHaj Holding claim.
Yes, but if you look at the judgment of Justice Giles,
right,
the claim for Mr. Abu AlHaj personally does not relate to the share transfer. Claims from Mr. Abu AlHaj personally was regarding slander. Only slander.
Will you take me to that point?
Yes.
No, tab 2 is the particular of a claim.
Tab 3, I'm sorry. Sorry if I didn't point out question, but at start, regarding the application for immediate judgment, the Justice Giles disposed of the situation regarding the Arbuckle case, which states that for mismanagement, you cannot jump over a company that has been mismanaged, old holding.
Well, I understand. Mismanagement should be, the company should be claiming.
And it was the shareholder, Abu AlHaj Holding, that was making that claim. Now, regarding slander, the judge says that it only relates to defendant Mr. Abu AlHaj. Let me find.
Okay, just go to the. Here's a claim.
Sorry, what?
The share is a claim.
Well, the shares claim at that point was rejected at start because the judge said that it was something that could be had to be heard by the court at that time, because there were not yet any proof or documentation that a hearing had to be done. Now, on the point of slander, now a company cannot be slandered to some extent. However, all the relation.
Sorry. We passed that slander or defamation era. We didn't have to talk about it, isn't it?
No, that's it, and it was decided by Justice Giles.
Yes, it was.
That was for the claim was only by Mr. Abu AlHaj. It was not by the company.
No. Today, what case we have? The shares claim only,
Yes.
isn't it?
So the
who's the
shares were
claimant?
transferred from Abu AlHaj Holding to defendant Sheik Sultan.
Right. So between personal to personal.
Company to personal. Abu AlHaj is not a claimant today. Abu AlHaj is not the one that transferred the shares.
I'm here representing Abu AlHaj Holding. I'm not representing myself. For the last
The Abu AlHaj Holding is.
after the last hearing, I was only representing Abu AlHaj Holding.
Yes, okay. AlHaj Holding is in here. Okay, AlHaj Holding is a claimant, isn't it?
Yes, that's the only claimant before you today.
All right. And Mr. AlHaj said he is representing.
Says that he's representing the company.
Right. And what's the problem with his representation now?
Well, basically, if you look at the section,
Yeah.
first of all, as I was going to point out to the court, the claimant has to be represented at trial. So, in order for a company to be represented, 35.41 states that you need to file an application, and you need to file a corporate resolution saying that you are the representative of the company. That's not been done.
Sorry, what article you're reading?
35.41 and 35.43.
I think I have submitted the articles of the company at the beginning, and it shows that I represent the company. So I was representing AlHaj Holding since it was started, and at this scale. So I don't know why we're getting to this point, but it's that's the fact. I represent AlHaj Holding. You can check that in the DIC. You can check it in the. And I was representing it for the whole time, the whole case. I'm surprised that we come to this point now, and we are going to present AlHaj Holding. Well, I'm happy that we are in the DIC, and they have the articles of the company, and it shows clearly that I have all the power to represent AlHaj Holding.
Get him, Lima. Say that again.
AlHaj, can you repeat what you just said?
I was saying I was always representing AlHaj Holding, and also in this case, since we started this case, I was representing myself, and I was representing AlHaj Holding. All the articles of the company, which is at the DIC, shows that I am the representative of the company, and that's what we have been doing this whole time in this case. So now I'm surprised that you're coming to this point.
So would you please ask him if when he said the record is with the DFC, he means DFC court or the DFC registrar of companies?
Are you referring to?
No, I'm referring to the DIC registrar. The articles of the company, which is the DIC registrar, says that I represent the company. And the articles of the company that is issued by the registrar. Submitted to the registrar.
And you have represented the company also in the previous hearings, is that right, Mr. AlHaj?
I'm sorry?
You have represented the company in the previous hearing before Justice Giles.
Yes, always. Since the company is founded, I'm a representative.
But I think it's...
Well, Your Honor, if I
Well,
may,
I think it's a bit late to challenge.
we challenge this at all time. And the last time we were before Justice Giles, we were surprised that, because at start, if you go through the file, there was an application made to have this a conference for an application by phone, and it was rejected by the court. Came in last time with Justice Giles, and there were no application, but the court just decided that it was okay, he was on the phone. We objected at that time, but it was with no consequence. Nothing happened.
And also, I remember during whether the CMC or during the pre-trial, you made no observation in regard of his appearing on behalf of the company and appearing by phone.
Last time when we did trial review, I objected to the fact, and I've asked for the transcript to be done. We're going to have it tomorrow because of the long weekend. I did object to the fact that today at trial.
Where is the objection, sorry?
Done at the end when Mr. AlHaj said that he would be by phone, and you asked him why wouldn't he come in?
Yeah, he gave me reason why he cannot come in.
He didn't give you any reason. He said you didn't want to give you reasons.
Yeah, but what you asked why he should not come, but you did not object. You did not say.
Yes, I did object, Your Honor, Your Excellency. You asked the question to him, why wouldn't he come? And he said he'd prefer not to say. Then I said I objected to the fact that he was not going to be here today. And if we go back to the question of having a witness statement, having him present, I refer the court to tab 29, where we filed an email from Mr. AlHaj that was drafted November 30th. Says, and I'm reading out of the email, which is tab 29 of the bundle trial, before being allowed to testify, a witness generally must swear or affirm that his or her testimony will be truthful. 2, witness must be personally present at the trial or proceedings in order to allow the judge or jury to observe the testimony firsthand. The witness is subject to cross-examination at the option of any party who did not call the witness to testify. Then this is something that was said by Mr. AlHaj.
Right.
Yes, I agree. And I'm ready to swear on your oath and to cross-examine. And by the way, since I filled the application for the CNC hearing and this, I filled down that I will be in telephone. And I confirmed that too many times. I don't know if I have confirmed that, like, how many times. I have no idea. I confirmed it more than once. This is what I'm sure of. In the application, when it was written, and I'm not surprised now that we're coming to this idea.
Well, Mr. Hassan, I think it's a bit too late for you today, before the hearing, to argue that Mr. AlHaj is not a true representative of the company. And I don't think it's proper to hear this now. An investigation for this point would jeopardize the hearing today. I think it's a bit too late to argue the point in regard of the representation.
Well, the rules say we can do all the applications that are needed. I have more to go on, just to say that he's not present, because on one point, to all due respect, in the rules, it provides for witness to be on the phone, even lawyers to be on the phone, at section 23.83.
We didn't have witness on the phone now. He's not witness today.
No, I know he's not a witness today.
Then you're talking about only representation, and then the rules you're referring to.
So he's acting as a representative. Is he considered to be?
But he's not a lawyer.
Yeah, I understand Your Excellency.
So the rule you're referring to, that related to the legal representation, isn't it?
It relates to that advocate.
Yes, but he's not advocate.
I know he's not an advocate.
That one I'm saying.
However, if I go back to what I just read to you,
That's related to a witness.
yes, it's related.
So he's not witness, he's not lawyer, Mr. Hassan.
Well, this is where there's a fine line.
I see your point in regard of the Article 3543, which is, I'm trying to think about it now, but in regard of application for appearing through phone conversation, I think
So,
it's something.
35, in accordance.
43?
35.14,
Yeah.
because at trial it's a different situation. So the claimant does not file any witness statements on it.
I did file on the application that I will do on a conference call. The second point, I never thought that I would do a witness statement. I thought a witness statement is the witness on the case cannot be me. So this is something very new.
Well,
I'm sorry, I'm not a lawyer. I don't know what the legal code. And that's why I was surprised that I need to do.
Well, Mr. Hassan, maybe this is a situation you can take advantage of. So he missed out that putting himself as a witness. So he's reducing the number of evidence in the case by not putting his own statement. So he's relying on one witness now, you know.
I
So
understand.
I think you can live with
Is
that.
it clear that the court will not consider him as a witness?
No, if there is no witness statement.
Now, there's another point I want to raise before we go to trial. This has been also previously mentioned.
Which?
Legal capacity of claimant. Look at tab 22. We've asked, made a request to provide documentation regarding a valid commercial license issued by the IFC registrar. Tab 22 of the trial bundle. And a valid and recent certificate of good standing issued by the IFC. Now, claimant 2 failed to produce those documents, and Justice Shamlan Al-Shawalehi made an order on this point. Now, as of today, we still don't have a valid license and any certificate of good standing for the company. Now, if we've provided the court with tab 24 of the trial bundle, that the company's directory shows that claimant 2, Abu AlHaj Holding, registration is non-renewed, and that claimant's license has expired on March 16, 2015, before even filing the case with the court.
Right, and what's the consequence of this?
Well, basically, according to Article 13 of the IFC company law,
right,
and I put the extract in skeleton, no person shall conduct or attempt to conduct business operations in or from the DIFC unless and until such person has been duly permitted to do so by registrar, and then it goes on to say what needs to be issued by the registrar, and the last one is along with a commercial license as provided for in the regulation. We admits that the claimant 2 does not have a legal capacity to act in court today.
Yeah, but the article was referring to doing business.
Yeah, well, doing business and
Not to
suing
use
somebody.
not to use your right to sue, which is very public right.
Court,
No, I'm just discussing it with you.
well, basically, I don't think it's capacity is all together. You cannot have capacity to do one thing and capacity to not do another. It's either you have or you don't. You can't be half pregnant.
Well, let me give you then this example. Let's suppose that Mr. AlHaj company is not in Dubai. It's authorized to do business in Switzerland or in Canada or somewhere else. So the company itself he's representing does not have any license to do business in Dubai. However, the defendant located within the DFC or in Dubai, so Mr. AlHaj come to Dubai to pursue his right to sue someone in a broad jurisdiction where he's not authorized to do business. Can we say, because since you don't have license here, you cannot do business? So I don't know why you link licensing to do business with pursuant of a legal right.
Well, basically, it's legal existence. You can't do business. Do you have the right to go to court? Do you have the right to purchase goods, sell goods within the IFC? Abu AlHaj Holding is a DIFC company. It's not a Switzerland company. So it has to obey by the law and the rules of the IFC.
I see your point, yes.
If a company or a company has been delayed in renewing the license, and it's a company that has been registered probably 10 years ago, and we have to communicate with the registrar to renew it, but that does not block any liability towards or claims from others. And it doesn't stop any legal cases or anything. That's something between the registrar. When I go to a bank, for example, I cannot open an account until I have renewed the registrar. But I don't think being delayed with the registrar, and they will be paying me fees, and I'm not resolving that. And one of the main things that is delaying this is the actions of the defendant, which is delaying it a little bit. But I'm sure that it will be solved, and it has. I don't think that being delayed on the renewing the license has to stop a case that has a big value.
Remind me, Article 13 of the company law?
13 of DIFC company law, DIFC law number 2 of 2009. Now, further on,
Yes,
Your Excellency, I wish to point out, and we filed it in the jurisprudence package.
right.
This is not the first time that Mr. Abu AlHaj has been involved in a court case in the IFC. Probably noticed that at tab 1 of the jurisprudence document that there was a case regarding Orion Holding Overseas Limited. That case, it's also mentioned that he has filed affidavits.
Your Excellency, I don't want, or if you may, I object him talking about Orion. And as per this point, he can see that at this case I have different legal advisors. They were acting on behalf of me. Siemens and Siemens were one of them. And then I have not been in any. The case was all the lawyers who are doing it, and then I had a settlement with Shua Capital, and the chapter is closed. Okay, I don't want him to talk about it or use parts of it against me. This is what happened. It's a case. I have Siemens and Siemens lawyers.
Sorry, Mr. AlHaj, nothing confidential in here. Sorry, Mr. AlHaj. He's referring to a court judgment. He's referring to a court judgment and public document, and nothing confidential with that. And I just, if you allow me to hear the point that Mr. Russell wants to make now. Please go on, Mr. Russell.
The point I wish to make, Your Honor, Your Excellency, is that AlHaj knows how it works at the IFC court. How it works, and that has filed with the court some files recently showing that filed on his side a witness statement. So I wish to point out that
Well, having experience once with the court doesn't make someone lawyer, Mr. Russell,
I understand the point.
or an expert of procedures, isn't it?
Since we've agreed, because this point was on, I wanted
Well,
to
I see your point. Like you saying he should not claim full ignorance of rules. Is that what you
That's it. That's
trying to say? But I don't know. Maybe that time he was not focusing, or he didn't know he might have another case in the future. I'm not giving him an excuse, but I don't think like going through a case will make you a lawyer. I'll tell you something. There are a lot of lawyers who practicing before our court are missing out a lot of procedures and believe me, they make the court life miserable once they apply before us. And I'm talking about qualified, trained lawyers sometimes.
I follow you on this.
Yeah, but yeah.
But basically, what I wish to make the point is that Mr. Not at this point in time.
I agree with you. On this point, I really agree with you. Mr. AlHaj have not complied with the lots of court orders and demand. I agree with you. And that's something would be dealt with in my judgment.
I want to say that I'm ignorant in this. And when he's referring that I was in the AFC court before, yes, I had cases in the AFC court, but I had lawyers. I was not involved. I didn't know that it's like medicine for me. Law is like medicine. I go to doctors, I just tell him the pain. He does the prescription. I don't know his terminology. So in other cases, Mr. Daniel that I had that you're referring to my experience, I have not been to the court. It was a case I had Siemens, and they had a settlement with Schwab. The details of the case, I don't see that there is the need for it, but you can go if you want to wait time for it. I'm ready to discuss it too. I have no problem. But after that case was closed, I lived in the UAE for 8 years. I had no problem on it.
Yes, Mr. AlHaj, I see your point. Yes, I see your point.
An allegation against me, there was nothing. So the problem between me and Mr. Hoyer, and we have a settlement when he was chairman of Shah Capital, and by holding was involved. And this case was ordered to me by Diwan al-Amiri to not to talk about it. So I'm just saying this to the court.
That's clear. That's clear.
I'm not supposed to talk about this case.
What is your final point, Mr.
The
Abdullah?
final point on that element is that no documents were filed also for standing.
You have not filed any document, only the document attached to the witness, isn't it? There is witness statement.
I did put in some documents that referred to the further particulars. That was ordered by the court as you remember.
Well, then he should take that a risk he's taking. I mean, if he's willing to take that risk, if he's willing to come to court without, I mean, I don't know. Have you applied for strike out? And I've seen you mentioning strike out in your
Yes, I mentioned the strikeout.
Maybe this is the point you still want to talk about.
I'm getting to that point, Your Excellency.
But I'm telling you, even before you go ahead and spend a lot of time on that, you could apply for strikeout earlier, not today. We are in a hearing now. I mean,
I understand.
The witnesses are here.
Yes, but if I may,
you can deal with the weaknesses of the cases during the trial instead of the application. Then you can finish that.
Yes. Trial review, you gave another chance to file. Nothing was done except for Mr. Martin Bouwer's statement.
And that's what I thought. That the only thing I have remaining to submit is the witness statement. No one told me I have to submit other things. And if I know, I would do that.
Yeah, Mr. Rasan, what I'm going to say, whether you apply for strikeout, you're going to invite me to wait the evidence of the claimant. Is that right? So
Yes,
you're going to say there is no evidence based on it's just mere normal statement. It's not supported by evidence. Should be struck out. Okay. If we go through the hearing, it's the same things. If you just find this claimant got no real prospect to win, or the witness is taking him nowhere, so you still can apply for dismissal of the case. That's what I'm saying. We came at the point. We can deal with the merit directly. I think the case is all about evidence. But I would like to invite you to go through, and you tell me what is the background of the case.
Well, basically,
yeah,
I follow you. It's just because last week when you ordered a last chance to provide witness statements, it could have happened. It didn't. Well, it happened for Martin
it's again, it might be an advantage that you can make.
Okay, I understand. The three criteria, anyway, I'll get later on.
That is a risk. So what I want you to see, we're not helping Mr. AlHaj against you, okay? We're not seeing AlHaj as a smaller party against you or whatever, okay? We try to survive the hearing.
I understand, Your Honor. So
we try to put both parties in equal footing, you know what I mean? This is like, but we do not try to jeopardize your right of defense as well.
I hope the defendant is not coming to use my ignorance to beat me in this case. I would like him to talk about the facts, not about things that I forgot to submit or things that he knows that I'm ignorant, totally ignorant in legal terms. But I have sent him a couple of emails and I tried to call him multiple times. He never answered. And so at the end, the court and the defendant have to take that into consideration. So I prefer that if you look at the facts of the transaction,
well, Mr. Russell,
they're trying to use or get judgment against me because of my ignorance in the law procedure.
It's okay, Mr. AlHaj.
The last point on this.
Yes.
We wanted to have it strike out, and basically our arguments.
Well, I'm writing down your application. I'll deal with it.
I know. And claimant had every chance available to bring forward this case. However, at one point.
Well, if you brought me this application last week, it would be really different.
Still, we're on a short notice here of 2 weeks. Well, at one point in time, if the claimant disregards all the rules of the court, because there are rules that have to be followed and laws by everybody.
No, what I'm saying, you could bring this application even before the pre-trial. You have not brought it. And now you're raising it now. You allow for the hearing to be set up. You allow for the judge to sit.
Oh, wait a minute.
Yes.
Sorry, with all due respect, I filed a motion to have foreclosure against the defendant because he hadn't respected any of the arguments. If I recall, at CMC, you said to me, well, he just filed with you further particulars. Do you accept that this can be brought in the case? Finally, I followed your order. And it was
No, you
brought-
accepted, you now followed.
Well, I accepted the situation because, like I said, we have to give a chance to everybody on this. However, at one point, then you made some orders for witness statements, for documents to be produced, and the guard everything, did not comply with nothing. At one point in time, it becomes a denial of defendant's right. Because to proceed in a case where the claimant has respected no rules, no laws, nothing, and still it goes to trial, and there's no witness statement at this point, and there's no proof.
I respect the rules of the court, and I respect, for that reason, I'm seeking justice in this court. So it's not about I'm not respecting. It's about, when a doctor talks to a doctor, they have their own language. So when you're talking legal terms with a judge, there's a common language. I had a problem, and it's my first time in my life that I don't have a legal assistant. Okay? So I'm trying my best. I have submitted all the documents that I know that I have to submit. Okay? So no one told me that, for me, a witness statement, I'm an Arab. When we say witness statement, that means a witness. I'm the claimant, so I need to have a witness. And I wrote the witness statement long time ago, which is Martin Bucher. Martin Bucher, he's the auditor that the defendant himself has assigned. So this is another point, and he knows the whole thing about the transaction, but the defendant couldn't make him say what they want. He just said the truth, and that's what I respect Mr. Bucher, what he's doing.
Claimant even...
There's no witness. I know people who have seen the facts, but they don't dare to come to this court and say something about anything about the member ruling family. So there is the scenario. It needs to take it from a different angle. So I'm requesting from the court not let the defendant use my ignorance and I have submitted what I have submitted. So if there's something really needed that I didn't know about, no, we can delay the case so I can submit it. I think that I have submitted everything.
Then...
That's my witness statement, I have not submitted. Because I didn't know that I have submitted on the witness statement. I thought we are just doing the particulars and declare. So that's what I thought. And the witness statement shall be from a third party who will be a witness. This is my knowledge. I'm sorry. But,
No, Mr. Russell, we are on a hearing date.
But that's what happened.
We're in a hearing now. He has a witness and some document. He tried to survive his case. Okay? I think I've heard enough on this strike, and I understand your point. I would deal with it in my judgment anyway. You will have a fair answer at least for that. And now I will invite you. I will invite Mr. AlHaj, maybe, as claimant, to address the matter. If you bring this mic here near me, Lima. Yes, Mr. AlHaj, Mr. Russian say you have not submitted any opening statement or any skeleton argument before this hearing, which is a requirement by law. This should be a skeleton argument that to be submitted before the hearing.
What I have understood that he's going to do it, and I will go on to discuss it in the case. So I didn't know that I have to do one and he has to do one. He sent me the bundle. And I told him, yes, this is okay, since it has all the attachments. So I thought he would do it. So,
a skeleton argument, that's a document you should submit that explaining the fact, the evidence, and the law, and all your reference you would like to make about the case to the court. But anyway, you're aware from that, but I know we already have particular of a claim, amended particular of a claim. We have your witnesses as well, so I think we might be able to pick up your case from what's already been submitted from your side. But let me invite you now to address this matter of shares, sale of the shares and the price. Mr. AlHaj, would you please go on? You got me?
What was the last sentence?
I want you to address the matter of the sale of the shares. Now.
Okay.
Yes, go ahead.
Okay. So just regarding the sale of the share.
Yes, this is the only case we have today. Yeah. Tell me what happened, what is the history? And yes.
We had different business relations with Sheik Sultan in the gold sector. First, he was our agent in Abu Dhabi, Gold Abu Dhabi, which is belonged to him, but it was an agent to Gold BMC, which was belonged to AlHaj Gold. Then Gold started to have two major big contracts that we had. The main one was the National Bank of Abu Dhabi, where Gold will be the sole supplier for National Bank of Abu Dhabi for gold, which also would take huge volumes from the government. It was a very complicated system. We have spent over $2 million developing the system with the bank. The business consultants in the bank, they were estimating that this contract would generate around $50 million a year, or between 30 to 70 actually. It was a big contract, and the Sheikh started that he was interested to be a partner and to help us in so many aspects, as he said.
So you showed him the potential, and he showed interest to be a partner.
No, he saw the potential. He knows about it, because first he was my agent.
All right, this is he's testifying at this point. It's not a statement.
After that, we started getting to Embed the project, so he knows about it. So he showed that he's really interested to get into this, and he sent his people to the bank itself. He studied the project very well. He went also by himself to the IT people, and he made sure that the system is really perfect. Also, we had another contract where we are the exclusive of a certain brand of gold, which is called PAM. This is the biggest gold supplier in the whole region. They have a volume of $4 billion. They trusted Gold to be their whole supplier for their product. This is a big, huge contract. This brand has 90% of all of the gold in Saudi Arabia, and they choose Gold to be their exclusive supplier. So those two contracts made the Sheikh interested in investing in the company. So we started discussing and multiple meetings until we ended up to set up a company in DIC. And then Gold instead of being owned by AlHaj Holding, will be owned by different shareholders. So they have he has sent his people. They made decisions for a few months, going back, and we have agreed to that the value of Gold is $60 million with all of this asset transfer and projects and that. So they told, we will not pay you cash. We will give you shares of the company. So we decided that. I told
this is testifying. It's not
Well,
presenting the case.
this is a background, Mr. Rasan. Yes, this is a background of the case. I would like to know what is the background of the case. Yeah, what's the first, set of shares you agreed on? No, a number of shares?
So first we agreed that Gold Holding will buy Gold from AlHaj Holding at $60 million. But they will not pay it in cash to AlHaj Holding, they will pay us shares. So we issued the shares for Gold so Gold doesn't belong to AlHaj anymore. Gold Holding gave AlHaj Holding 60 million shares for Gold. And then the idea is what also to raise around $80 million for a big Canadian company, which is called Bango, and we signed an MOU. So the idea is that the Sheikh promised us to invest between 70 to 100 million dollars, 40 of them from him and his brother's fund, and from SBK and SBK Holding, and from other investors.
What is FCK? Sorry, what is FCK?
SBK Holding. It's the company of.
So it stands for what?
Sheik Sultan Khalifa Sultan, the popular SBK Holding.
Okay.
So he, I don't know now, I saw that SBK came, they took 3 million shares, no, they're part of the group, and then he took, he wanted to take the 2 million shares in Class A, because, Class A shares controlled the company. So we had the contract, we gave him the shares, and we're waiting for the next week, because he has to transfer me those shares, and the other shares, he has to put it in the company, the treasury of the company. But the agreement was that we take the Class A shares, because they are the controlling shares. Controlling in terms of their voting powers, not in terms of profitability. So we made a resolution. He took the shares, and he never paid.
To follow, I don't really understand what he's saying now.
So tell me, what was the price of the shares?
He acted in the company as if he has invested all his money. The first decision he made is to fire.
No, Mr. AlHaj, before you reach that point, I would like to know. Before,
We don't understand what he's saying.
We cannot hear the microphone.
Hello, Mr. AlHaj. Would you please slow down your speech?
Okay.
Okay, slowly, and speak up as well if you can. But at least the recording would pick up everything he's saying. So you would have transcript if you would like to. Anyway, Mr. AlHaj, please slow down, speak slowly, and
Okay.
tell me how much the 10 million shares worth.
$10 million.
So the share price is $1 US dollar.
Yes.
And based on what this evaluation?
Based on the evaluation that we have. Okay, when we have registered the company, we made a company that is authorized, because the idea that we were taking the company public. So the structure of this company, we had a meeting with CEO of Nasdaq Dubai, Mohammad.
Is that official meeting or?
So the idea is that we're going to do public. So we issued 200 million shares of shares. No, it's called 200 million shares, 60 million shares issued.
Who issued? When you said we, you mean whom?
The shareholders. So there's around 13 shareholders.
Right.
Okay. So the company has an authorization to issue for new capital for an IPO up to $200 million.
Okay.
So our agreement to the end that we went to Nasdaq Dubai and we're going to raise this money through Sultan.
Yes.
And to have it public. He took the shares after we signed and we submitted the shares, and the shares were under his name. He made a board meeting and he fired me from the company. Then he hired his 2 office managers, whom are his witnesses, as the 2 managers instead of me. And he hired Martin Bucher as the auditor of the company. And the first decision, they fired me. They took control. They, all of the employees have stored everything in the company, even small computers. All
I see. And now, Mr. AlHaj,
everything is taken.
now tell me what evidence you have that this share is the shares that transfer to the defendant is payable. What evidence you're relying on in this case?
He has taken a
No,
share.
what evidence in your hand now you want to rely on?
The first evidence is the transfer of shares.
Sorry.
At
Well,
its
okay.
value.
There are transfer of shares. Okay.
At
Secondly,
specific value.
sorry.
At a specific value.
What do you mean specific value?
Like the share has a specific value of $1. So one share is $1.
That is evaluated by the company, which by you.
But not by the DIC.
Okay, see. And do we have this evaluation in the case?
Yes, and we have the resolution of the Sheikh accepting it, and all the directors.
Is it attached to the case?
It was.
Is it attached? Is it before me today?
I think it's attached.
You think?
Shall I look at it?
Please.
The resolution that says for the transfer of shares.
Where is that? It's behind what? What's the name of the document? Tell me. Do you have the table of content? Do you remember the date?
No,
Is that 21st of September 2015?
I don't see it in the desktop, the bundle. Probably it's in the
It's called shareholder resolution?
Yes, is it?
It's called shareholders resolution?
Yes, yes, probably. No, this is regarding the shares.
And then what?
It's called the non-cash share transfer.
Is it agreement or resolution or what?
Resolution.
Are you able to assist Mr. Daniel, or it's not in here? What he's talking about? Is that somewhere in here, in the case?
Cash share resolution, I haven't seen.
No, yeah, I haven't seen neither. Okay. So, this document is the evaluation of the shares we don't have before us, Mr. AlHaj.
No, I just sent it by email to Daniel and to the VIC. For the court.
No, you can't email. We're in the middle of the hearing. Come on.
Yeah, I know, but it's already with Daniel now, so I think he knows about it. Because it's signed by the defendant himself.
I just asked him and he said he didn't know. Yes, you may continue. What other evidence you have now?
Sorry?
What other evidence you have?
The resolution, in front of the shareholder resolution, we made a resolution that is going to buy 10 million shares.
It said to buy? No, the resolution said to buy. Are you sure? You need to be very careful with the termination you're using.
For me, the term buying is taking something for other things. But what was the term transferring of shares?
What resolution you're referring to? What resolution you're referring to? So I can see what's the language of that resolution. No, he's referring to something else now. Porter. Yes, Mr. AlHaj. Now, what resolution are you referring to now?
So I think table 6.
Table 6. Tab 6. Yes, where you reading? It's the shareholder resolution, Gold Holding Limited. And
The transfer of shares, right?
yes, I cannot see any date of this document, but it transferred 8 million again, 9 million Class A shares transferred to Sheikh Sultan bin Khalifa, 8 million Class shares transferred to Sheikh Malik Al Sabah,
Yes.
then something for Irania, and okay.
So,
Yeah, it mentioned, it doesn't say pay, it says transfer only.
yes. So
Yeah,
that's-
where you brought the word? Sorry?
So this transfer of shares, he's saying what it was like a gift.
No, I'm asking you. You should not ask me. You should prove why you transfer it. Why you transfer it for? Why you didn't mention the price, the payment, the method of the payment, or anything?
Because all what we need is the resolution. You know, we have an agreement. We just need the resolution to send it to the registrar. So this is it. But our agreement for this, it's shown the transfer of shares in the resolution.
And so this is your definition of a transfer. That means a sale of shares.
And the fact, if you buy a car, if you buy shares, or anything, you don't do a contract that we will sell. The broker house transfer it, you just sign the transfer. So you transfer.
You see, I see your definition to transfer. Yes.
Well, what we want to consider it as the transfer is like a gift. So this is up to.
No, I'm talking about denial. The defendant denying that he has to pay anything in return for this transfer of the shares, because the consideration is that putting his name in the company, so the company would benefit from his name in it, and to expand and make more business. That is the core of the defense. So the defendant is giving us another interpretation why there are no price, why there are no method of repayment of the share price. So, and now I'm asking you, when you said sale, whether it's a sale or it's transfer or it's a gift, it's something you have to live with now. But I see your interpretation of the word transfer. You want to tell me it's a sale, yeah?
Let's say Your Excellency, let's say I want to sell you shares in or a car or a house or whatever. When we go to the regulator, he will ask for me. He doesn't care what kind of contract I have with him. He will put for me to sign on the transfer of my house, for example, or of my car, or this. This is what they request. So the transfer of an asset is at a value. It didn't say at 2 euros or 3 dirhams. It has a specification.
Well, excuse me, Mr. AlHaj, you're not talking about family arrangement. You're not talking about very basic business. You're talking about a very sophisticated business. A professional person like you should put things in a place. Everything should be clear. Everything should be. You're talking about hundreds of millions of dollars.
Yes.
Then you should be very accurate about everything. You should record everything. You should record your right. So the contract should reflect everything. That's what I'm saying. No, I'm saying you show me where is the consideration. I mean, what he has to pay back.
He has to pay the $10 million. That's what the $10 million shares that he has taken.
Yeah, I agree with you what you're saying. I'm saying show me where the evidence.
It was transferred to him. This is the evidence. It was he had 10 million shares. They have been transferred to him. So he has to pay.
Okay. That's so. I got your point. So you said the transfer is evidence that he has to pay.
A transfer of shares he has to pay, as I have agreed with him. Plus, of course.
I see.
Now, on the first hearing, in his first defense, he said that he had paid it to the treasury. Then he said no, it was a gift. Now he's changing, as you can see in case number...
Sorry, where he said he has to pay for it?
On his first defense,
Yes.
he mentioned that he had paid it in full to the treasury.
Where is that? Can you take me through that? What paragraph of his defense? What paragraph of his statement of defense?
Have to look for his first defense.
It's behind tab 10, I guess. Have you found it yet?
Yeah, no, because Daniel didn't send the attachments of the bundle.
I told you it's behind tab 10.
But I don't have that then.
So go on. What happened next? Then have you sent him any emails or reminders that he has to pay or anything, or any notice of anything?
Yeah, of course, verbally. I have.
Verbally.
I would like the court to take into consideration
Yes.
the way people in this country engage in business, especially when there's some people from the room capital. There's certain ways that they engage in business.
Well, yes, I understand there is no one way to do business. There are so many ways in doing business, whether for royal families or normal people. Business is arrangement between two gentlemen or more, in any way.
Yes.
Right?
So he got the transfer of shares. He's supposed to pay what he got, besides his promises, other promises, but this is something else.
You want to address another evidence, Mr. AlHaj? I will come back to you towards the end, okay? And I will allow you also to ask witnesses some question if you wish this afternoon. But do you want to say anything in regard of anything extra in regard of the transfers of share?
The share certificate itself, it all shows the value signed by Andre and I forgot someone else. So the share certificate and the resolution and yeah, I think this is enough to show that he took the shares and it's guaranteed. After he took the shares, for $1 of value. And he took Class A shares and also because he wants to do, he will raise other money as he was promising.
Okay, Rana.
My money.
Yeah, I'll stop now here with you, and I will allow Mr. Rasan to defend what you have just said. But please, please don't stop Mr. Rasan. Don't talk until he finish, or take permission of the court if you would like to make any objection, Mr. AlHaj. Am I clear?
I can make an objection?
Yeah, seek permission for the court before you talk.
Yeah. Okay.
Yes, Mr. Russell?
Thank you, Your Excellency.
You might address the merit of the case.
Well, basically, as an opening statement,
What I said, when I say the statement for Mr. AlHaj, doesn't mean evidence. Even if a lawyer, he will have to give me the background, he need to explain everything. But he can't rely on his statement as evidence. Are we clear on this? Go ahead.
so in this case, you're in sale of shares. And on the other hand, defendant provides the court with the document which is called D24, which everything revolves around this document. Under tab exactly 17 of the trial bundle. Now, there is no document whatsoever that was filed by claimant showing that there was a sale of shares.
Are you referring to the memorandum of understanding? Yes.
Yes, I am, Your Excellency.
With the two initials in each page?
October 13th,
Yes.
2014. Document is the only document that you can find in the file that has been signed by both relating to exactly those shares.
So this is the only signed document by both parties? Yeah.
Transfer of the shares. Now, this document is very clear on the fact that 9 million shares will be transferred to the and it is for his support to be provided by him. AlHaj earlier mentioned the IPO. You can find it at section 2.1.
No, before you depart from this document, will you please show me the consideration, the reference to consideration in here?
Well, it's in two parts.
Yes.
First article is transfer of class shares, of A-class shares. As AlHaj holding,
Yeah, will transfer.
H, which is 1.1, will transfer 9 million shares, Class A shares, in the name of SKSAN, which is the defendant, and will attend to all administration requirements required to register such transfer. Now, there is no mention of any price or value whatsoever in this document. Now, on the other hand, go to Article 2. Support to be provided by SKSAN. As a shareholder of Gold Holding, SKSAN agrees to provide the following support to the business. Relates also to what Mr. AlHaj has said.
And you're saying this is the only obligation?
Yes, this is the only obligation my
For
client
SKSAN,
has
yeah.
regarding this transfer of shares.
Nothing about payment.
Nothing about payment. Nothing also about the payment of the previous 1 million shares that were issued earlier in 2013. Now, it also continues and states at Article 3 that my client will not be able to sell those shares.
Article
4, sorry. SKAN
Yeah.
agrees that if it negotiates to sell any of or all of its Class A shares to any third party, it could also make an offer to AAH, which is AlHaj Holding,
the priority to buy.
to acquire it. So it's a first refusal. So, document has been sent to AlHaj in identified, along with the amended defense, that this was the document signed by the parties regarding the transaction. Never denied this document, has never denied the content of this document.
I never denied it, but when did you submit it to me?
No, wait, Mr. AlHaj, don't talk.
Okay. Sorry.
It was submitted in September with the Now,
Yeah, I see. No, go on, please.
so in this case, this document clearly shows that this is the agreement between the parties.
Right.
Now, then the shares were transferred the next day. And nothing happened. There is no proof, no document showing that at any point in time, Abu AlHaj Holding has claimed any payments from my client. As it is mentioned in my client. For the action, asked to him to pay any kind of amount. I also point out that Mr. Abu AlHaj has also mentioned in tab 6 a corporate resolution that shows that Sheikh Malek from Kuwait also received no claim of money whatsoever.
I object, Your Honor.
Let him continue. You wait.
Sheikh Malik is a different story. He's paying.
Mr. Abu AlHaj, write down your note. I'll come back to you.
I thought you said I can object. Okay.
Yeah, write down whatever you want, and then I will come back to you, please.
Thank you, Your Honor.
So,
So you, Sheikh Malik has received the transfer of shares, also
according to tab 6,
in a similar way.
in a similar way. Not a similar way, the same way.
Same way. Exactly same.
I have a copy of his agreement, which is exactly the same as Sheikh.
And then from your,
So,
what's the consideration? So transfer of shares
to my client?
against his name to be in a company.
Well, it's more than that. It's more than that. And you have it at 2.1. It will act at all times in the best interest of gold holding and will use responsible efforts to support the business. You can, that's 2.1a. B, make reasonable efforts to increase the business. And I'm summarizing the paragraphs. SKSAN will assist with the IPO, which Mr. Abu AlHaj mentioned, public offering. And SK will make reasonable efforts to introduce other potential investors to gold holding who may wish to acquire shares in the company either prior or during the IPO process. IPO being the initial offering.
Yes.
So this is the consideration for the agreement and the transfer of shares. This is the basic agreement between the parties, and there's no proof whatsoever, much to the contrary, because Mr. Abu AlHaj has said the shares were transferred. My client acted as the chairman of the company and mentioned different contracts that happened after that, which occurred. The mismanagement case is altogether settled, so we won't go there. And also, on the last point, is that the defendant, there's a timeline here that's missing in Mr. Abu AlHaj's statement. The fact that these shares have been issued in October 2014. When he says that he was fired, this occurred like 6 months later on, which is in 2015, which was more in March, which is not the object of this hearing today. However, there's a timeline here that does not coincide with the reality. It's clearly that this deal was made, it was executed by all the parties, and there are no proof whatsoever at this point showing any agreement to the contrary to this agreement D24. That it's not denied by that's our position on that.
That's all you would like to address in regard to the merits of the case?
Well, regarding the basics of the case on share transfer, yes, this is the only point. Naturally, say that this case has no reasonable ground at this point in time, since there's no, because if we go back to Mr. Martin Bouwer's testimony, there's nothing in there that shows that he's privy to
Go to shortly. Yes, Mr. AlHaj, you have heard Mr. Rasan. You want to comment in short, please, huh?
I was trying to open the contract or MOU he was referring to. So I never denied this contract. It's like another obligation on him to do besides this transaction. So he's not just talking the A-class shares without the other obligations like to help us get the investors, the IPO, all of the services was mentioned there. So this is a plus thing. And why he's having the, but that does not mean he's taking it for a gift or whatever. This is proof that he has other obligations too, since he's taking the control of the company.
Well, you trying to make evidence or proof out of your own guessing, Mr. AlHaj?
Okay.
You trying to make evidence out of your own guessing?
Not guessing. So tell me that he took it for gift. Okay, I want to say that he took it for, as he said, for this consideration in the contract that I don't see in front of it, but I don't lie, I didn't deny it, and I see, okay, I know what's in it. But I'm asking, has he done any of these things? Not even one of those things he has done. Okay, so that I'm assuming, that it's based on this contract, even though this contract is an extra contract, it's an extra obligation on him that he has not fulfilled it. So I don't think that's.
Well, and this is a very new point. This is a very new point of fact and law. We have not dealt with previously.
Sorry.
What you're saying now, he have not fulfilled his obligation that mentioned behind Article 2.1 in the Memorandum of Understanding. And now I'm saying you're raising a new point of fact and law.
He has not fulfilled any of those points, including that he cannot register any company in the gold industry. He did 5 probably. One of them is the IC itself.
No, I see your point. I know what you're talking about. What I'm saying, this is completely new point. You should not raise it now, at this very late stage. And maybe this would go along with the mismanagement of the company.
If he's depending on this contract, then okay, this contract, even though this contract he is not fulfilled, but the fact is that this contract is an extra obligation on him to do in order to take those 9 million shares, plus paying them, and plus getting another 100 million shares. To fulfill a contract that he knows about, that he has to pay $80 million within 3 weeks after. But we ended up knowing that he was inside trading some stocks of cattle. So I don't want to get into other things, but this was what's happening. So now, if he's saying now, and he wants the court to tell him, oh, sorry, it was a gift, Mohammad, then I cannot say anything. But what I know, as the judge in the last hearing said, there's no such something you take shares for nothing. So then he said, okay, it's for a gift. He mentioned that, you can go to the hearing. I remember he said that. That was a gift. So if it was a gift, would you act and fire the one who gave you this gift? Fire him from the, come on. He was acting, and the other evidence, and the most important evidence that I'm requesting, that he has fired a kid, assuming that he has invested $10 million, and he's requesting this $10 million back with damages. So all of these things, he's saying one time he pays a gift, and one time he says that he paid it and he wants it back with damages. So I don't know, like if the court sees that that's no conflict and that's okay. Well, for me, I don't think that's professional. That's not ethical, actually. For me, as the judge said, if something is taken, there's something on the other side shall be taken. Transfer of shares, there's money. at $1. Like I said, I'm with $1, then it's with $1. Shares, transfer of shares $1, he has to give me $1. If he refers to the other MOU, okay, did he implement anything? No, zero. So he has to pay the $1. He didn't take it for a gift. Since he's saying it's a gift, okay, considering this MOU, this proves that he is lying. That it's not a gift because he has obligation. So I don't know from which way he's coming from, which I don't want to guess. What I know, one fact. I have no lawyer. I have a court in front of me. I have a journal with all respect. I respect you. Even when you came to the room, I stood up. You don't see me, I don't see you, but I stood up out of respect. He took those shares from me. So if
yes. Mr. Al-Haj, would you please allow me, please? Mr. Al-Haj, what I'm trying to say, the court is not giving opinion, okay? What the court trying to do is to discuss things with you. The court tried to deliver and simplify the case of the other party for you. What I'm trying to say, when I say what the other party said, that doesn't mean it's the court opinion. You're going to see the court opinion and order in the judgment only, okay? Whatever you hear from me here today is not opinion. It's not what I believe of. You got me? What I'm trying to put before you, I'm trying to make it clear the other party's argument, so that would help you to defend, okay? This is first point. The second point I'm trying to tell you again, the other party's defense is that it's not a gift. The other party's defense is that the consideration is what mentioned in Article 2.1 of the Memorandum of Understanding. We didn't have any defense that says it was a gift. Okay, you should be very precise. You should not keep. Don't feel any negative, and don't try to attack anyone, neither the court, yourself, or even other party. Just calm down, Mr. Al-Haj. We are here to hear you, and you know that we help you a lot. We try to accommodate, protect this hearing. Yes. I just want you to be fair with yourself first.
It's my first hearing in any court, by the way, and but I feel comfortable and adjust, and I just want to say a fact. If I was wrong, then I'm wrong. If I was right, I was right. So.
Well, but Mr. Al-Haj, if you are in another country, you might not reach any court trial even with what you are doing here.
I agree 100%.
Well, thank you very much for your understanding.
No, I understand and I really appreciate that. I know that the court was so kind, or Rahim and I, they knew that I'm ignorant in this, so and also with the other legal things, I really apologize and I appreciate what the court is doing. But
we don't seek any apologies. I'm going to tell you something. Now we're going to hear your witness. We might take a short break, maybe 5 to 10 minutes. Then we're going to hear your witness. We'll hear from Mr. Rassan first. Then we will break for 5 to 10 minutes. Then we'll hear your witness. So Mr. Daniel Rassan would cross-examine your witness, and he might ask him a couple of questions. And then we take lunch break. Then we come back, we'll hear the witnesses of Mr. Rassan. You have two witnesses, Mr. Daniel? One witness for for the defendant. Then we'll come back to you. And then after hearing both witnesses, I would like you to take some notes and write them down. Then you can say whatever you want toward the end of the trial.
Yes, I'm doing that now. And
I'm anticipating that we might finish the trial today. We might not even have to go to the next day. So we might vacate tomorrow. We might finish up today. It depends how long we're going to spend with each witness.
So,
am I clear? Now we'll hear Mr. Rassan, then we'll break. You didn't have to say anything now until after the break.
Okay.
Thank you.
Thank you.
Just
yes,
shortly on a couple of points that were mentioned by Mr. First of all, Abu AlHaj Holding is still the majority shareholder of Gold Holding. And it has not the control of the company. Majority shareholder holding 51%.
Okay, so
Second point, 6.5 of the MOU, out loud for you. Upon signing this MOU, all the previous share options mentioned on previous agreements offered to SKSAN will be canceled. This agreement was canceling all previous discussion and agreements that could have.
sorry, what agreement?
This is the MOU,
Yes.
piece of Article 6.5, the last. Now,
You said it was cancelled?
no, it says that previous
Yeah.
share options and agreements were.
Okay, so this is the only standing document
That's it.
in regard to the sale of
That's
shares.
it.
That's what you're
And
saying.
it's at 6.5.
I see.
Another point on new facts regarding the fact that defendant 2 would not have made his support according to the MOU. This is, first of all, completely new on one hand, and like you mentioned. And the other point is that even if it was mentioned, doesn't mean that payment owed on the shares. Because if the shares were transferred, you can now only, if the counterpart has not been given, you can ask for annulment, but you can't ask for payment
But I see one.
when there's no payment coming mentioned. The last point, D24 was not available before Justice said by Justice Files in his judgment that this is why a gift could not be done and read the
That is my recalculation as well. Well, Mr. Hassan, then we'll break for a short time, 5 to 10 minutes. At
Okay.
Lima, you might prepare the witness, so we'll take him after 10 minutes. You just tell him what he have to do. Yes, and I will give him some instructions when I come back. In 10 minutes?
Thank you.
I'll be back in 15 minutes.
10 minutes.
Okay.
All rise.
Close and speak.
This Sheik Sultan.
Okay, I will call you from my other line.
Yes, please.
in the world. All of you, what I will say to the judge, never happened this in the court. This I'm so harassed on this trial. I have no protection here. Taken every human right on international court level. I'm here on a court.
We're not aware.
We are in a court case and they tried to remove me.
Yes, I'm there.
Okay, all right. Rise.
Good afternoon, all. We back here to hear the witness, Mr. Martin Boher. Mr. Boher, would you please come to the box of the witness?
I swear by Almighty God that the evidence that I am about to give is the truth, the whole truth, and nothing but the truth.
Thank you. Please be
Have a seat, please. Imam, would you please put his statement before him? Yes, okay. Yes, Mr. Rasan, Would you just remind me where the witness statement of Mr. Buher? Am I pronouncing your name right correctly?
Bucher.
Buher.
You do it perfect.
Thank you.
His Honor.
Right.
Tab 9, Your Honor.
Behind tab 9? Yes, I see it. If you open tab 9, you see it?
His Honor, His Excellency, you allowed me first.
I will allow you to say anything.
Thank
Just
you.
wait with me. Is that you? Do you see your witness statement?
Yes,
Behind
I
tab
have in
9.
front of me. Correct.
Is this your witness statement?
This is my signature. Correct.
Okay, so if there is anything you want to amend or change regarding this statement?
I tried to be very specific on this case. Of course, there is a lot to say about this issue, and I tried just to make the witness statement specific on this case. But there is a lot around which there are other issues, but belongs to the same case, His Honor.
Yes, thank you. I understand that. Mr. Bahar, the central case in here, the sale of shares only, that is our consideration today.
Correct.
And the second point, we already have your witness statement written before us. So we don't want you to repeat the same things because we have it written. You are here today because you expose yourself to be cross-examined by the defendant. So the defendant will have some questions to you about your statement. Then you will hear the question from him and you will answer according to the question.
Correct.
You understand me?
I understand clearly. His Honor, you allowed me first before we start to make a mark.
Yes.
I'm very surprised I got approached on this court, very, very unfriendly now. And I was forced to leave this court. I believed, at least during the time this session of court is going on, I will be on the protection of the court and doing properly my statement and not getting approached in a way that they taken me away my passport and my goods out of the court case. Of course I collaborate. I'm here with my heart. I'm here in the hand of God, and He is the only judge, and I did this now in the name of the Quran, in the name of the Bible, and I believe in the fairness and the just.
Yes, sir. I see your point now. What you are in the protection of this court, in protection of the law of UAE, in this courtroom. I'm told by the registry that you are already approached by the police or CFI. But that is maybe a criminal proceeding, not subject of our jurisdiction. What happened in this courtroom is my business. What happened outside this courtroom is not my business. But I'm sure in this country they are law. You must have access to lawyer or to anything else, and that. But still, again, it's not my jurisdiction.
Definitely. I just wanted to mention what happened during this trial, because this trial is under your authorization, under your protection, and this happened during this trial.
Right.
Not after, not before, during.
Thank you. I understand that. As long as you are in the witness box, you are fully protected. And the courtroom. Yes, Mr. Daniel Rassan, the witness is yours. Do you have a question for him?
Yes, I have.
Yes, please.
Now, if we look at your testimony, your witness statement, Mr. Buha, I see that you are here today as the chairman of the Financial and Audit Committee of Gold Holding. Is this right?
This is correct as a non-executive director.
This is under which title you wish to testify today?
This is the title I'm registered. I'm a non-executive director and has the mandate as the chairman of the Finance and Audit Committee, correct?
Are you a shareholder?
This is my official title.
Are you a shareholder of Abu AlHaj Holding?
No.
The director of Abu AlHaj Holding?
No.
Are you an officer of Abu AlHaj Holding?
No.
Are you an executive of Abu AlHaj Holding?
I think when you read it, the DIFC register, you don't find me there. I'm not at all.
Not executive.
Yeah, no.
So you're not related whatsoever to Abu AlHaj Holding?
Abu AlHaj Holding is a shareholder of Gold Holding, so I'm related.
Wait.
I mentioned you didn't listen. They are shareholder of Gold
Yeah, but
Holding.
are you a shareholder of Gold Holding, of Abu AlHaj Holding?
I'm shareholder of Gold Holding.
Of Gold Holding, but Abu AlHaj Holding.
You ask me how I'm related.
Yes.
Correct?
So you're related as co-shareholders of Gold
No,
Holding.
no, no. I'm related as a partner.
Of?
As a partner of Abu AlHaj Holding because the both of us are shareholders.
Are you an employee of Abu AlHaj Holding?
No.
Aware of the financial situation of Abu AlHaj Holding?
No. His Highness, His Honor, this has nothing to do with the case.
No, it has to do with
Oh,
the
okay.
case.
All right.
Because we need to see your connection
Oh,
and the
okay.
source of
Yes.
information.
Sorry, sir.
Yes.
In paragraph 5 of your witness statement, you refer to an annex marked 1. Go to the documents which follow or attached to your witness. Document 1.
Do you know what's the question, Mr. Bohar?
Can you repeat, please?
Isn't it not right that this is, what we find at document 1 is not an agreement regarding the transfer of 10 million shares from?
There happened a mistake with the document.
Reference. You made mistake with reference?
With the numbers. This is
Supposed to be number what?
the appointment letter for non-executive director. I have it.
Can you show us a document that relates to the?
What you supposed to refer to? Your time, Mr. Bohar, you're not in a hurry.
There happened a mistake with the attachment and the numbers.
Go to any other numbers.
When His Honor allowed me, I would like to resend this. There happened a mistake, and this contract is in my laptop, and I just realized now here.
And your laptop is not with you anymore?
Correct.
Right. So you're saying this is a wrong reference, but
Correct.
you have the documents not attached as well. That is your answer.
I see now that I didn't attach when this is what I gave to the court, so I must made a mistake, because as number one, I have here the acceptance as a non-executive director, correct?
The document you wanted to refer to, what exactly? You didn't have to send it to me. Tell me where it was. What kind of document?
There was an email.
Email is not an agreement, no? You're talking about agreement here. You're referring to agreements, not? Copy of the agreement.
Finally, for me, is a clear agreement. Where the acceptance of a share certificate is for me a very clear agreement, and a verbal agreement is as well an agreement. So the agreement finally was very clear that the defendant take the shares in order to participate and to pay the 10 million. So this is for me a very clear agreement, the acceptance of the shares. And the conversation...
Oh, no, we need your opinion now. You just
Okay.
need to answer the question.
Yes.
Thank you very much. Yes. Yes, Mr. Russell, you may.
Yes, could you go to tab 17, please?
Yes, sit 17. You found it?
No.
Tab 17 of the book. Not
Uh-huh.
in your
Behind
documents.
17. Behind 17. Are you there? Do you see the title?
Buher, have you ever seen
So,
this?
Bihar, are you with us? Have you reached the document? We didn't.
I saw it, this memorandum of understanding. I saw it.
Right, so what's the question now?
Question, is this the first time you see it now?
No. Yes, correct.
Were you present?
I saw it.
Were you present when it was signed?
No.
Further question, Your Honor.
That's all? Yes. You sure? Can I talk to Mr. AlHaj? Yes, Mr. AlHaj? Hello? Mr. AlHaj?
Hello?
Yes, do you hear us?
Hello?
Yes, Mr. AlHaj.
Yes, I hear you.
Okay, if there is anything you would like to clarify with the witness, if there is any question to the witness from your side.
Yes, first of all, I want him to repeat what he said, what happened to him while he was in the court.
Yes, I got...
Objection, Your Honor. This is not in the...
Wait, Mr. AlHaj,
Yes.
we hear that already. I said, do you have any question in regard of his witness statement?
Yes, yes, because in case I have heard what I thought I heard,
Yeah.
that they have harassed him and this and that, and I know Martin Bucher, if he goes, like, he's going a statement, giving a statement in court, and just
No,
a
no,
few
no.
minutes before giving the statement, harassing him in order just to confuse him and doesn't know what and where. So this is, I don't think that this tactic is being used like 1,000 years ago.
Mr. AlHaj, Mr. AlHaj,
I just want to...
Mr. AlHaj, there are no...
I'm just saying, like, is Martin in a condition for to do a witness statement? This is my question to Martin right now. Martin, after the harassment...
I'm very confused. I'm very confused, and I feel me not good.
Excuse me, you cannot talk without the permission of the court.
Sorry, Honor. Yes.
Mr. AlHaj, please listen to me, otherwise I'm going to cut the line.
Okay, so this is first...
You listen to me, Mr. AlHaj.
Yes, I'm listening.
There are no harassment in the
I feel me
courtroom.
not good.
The witness is not
Not
saying
good.
anything. The witness is just responding to the couple of questions asked by the defendant lawyer. The witness is not asked to say anything or not to say anything. The witness is here to be asked about his statement that he filed with this court.
I know, I just...
And yes, and I see no problem with that. The witness is granted full confidence to say whatever he want to say. But we are not here to hear the witness. We are here to cross-examine the witness. We already have what he wrote, which you submitted to us. That is written, that is recorded in the court file, which is a public document. There is no room for your statement. And now my final question to you is, there is any question from your side to your witness about anything written in his witness statement? Am I clear?
Yes.
Please.
The main question that the defendant asked Martin
Yes.
was if he attended the meeting with
The signing.
agreement.
He asked him if he had... Yeah, and he said no.
And Martin said no, yes. Because Martin said no about signing the MOU agreement, because I know he was not there. But about signing the resolution of the transfer of shares, Martin, were you there?
Correct. Yes, correct.
Okay, he was there.
You were there? You were there on the transfer of the shares?
Correct.
And it said his signing on it, and you have you witnessed him promising that he will pay for those shares and for more shares that he's going to bring from SBK Holding and other shareholders within a few days after signing those agreements?
This is not in the witness statement.
Is
To this, and this is hearsay.
yes.
Excuse
Yes,
me, this is, yes,
I witnessed that.
This is not in the New York evidence. Would you refer me to the paragraph of his witness statement saying this, Mr. AlHaj?
Sorry?
Would you
I
refer me-
mentioned this.
Mr. Buhar, don't talk, please. When I only answer question. Yes, Mr. AlHaj, would you refer me, take me to the paragraph in his witness statement saying this he would like to... If it's written, it's written there. If it's not written, then you're asking him about new information.
So that's it. I asked him about if you witnessed the resolution of transferring the shares, the conference that...
He should have written that. He should have written that since the beginning. Any other question? Other question? Again, another question about his statement.
I thought that it would be no for both of them. I just want to clarify that when he says no, he meant no for that agreement, MOU, which has nothing to do with it. But the transfer of shares, yes, he attended that. So this is what I want to confirm.
Mr. AlHaj, the purpose of the witness statement, that the witness statement is saying what he have seen already. And I asked him if he would like to change or add anything to his witness statement at the beginning, and he said that's it, and that's whatever he already know. Okay, there we have, see, it's not a floating procedures. We have a very codified, very clear procedures. What the witness has to say, what the witness has to answer, Mr. AlHaj. You might, I understand you're not a lawyer. You don't understand the rule perfectly, but this is a choice you have taken to come to trial with. I'm just reminding you what's the rules. I'm the master of the rules today here. Okay.
So
Now read the statement of your witness and see if you would like to ask him any question. If you didn't have any question, we can take the witness of the defendant. Then you can ask him any question about his statement again.
So again, my question that I have questioned him already is all in his statement, so there's no need for it. Is that your point?
Yes, if it's there, I'm going to read it. You can make submission later. You can write to this court what you want to, what you would like to address.
My question was based on the question of the defendant when we asked if he saw or he attended the signature of this contract. So he said no. No,
I understand this point. Just jump to the next point. Do you have another question?
No.
Not for now.
I want to notice the incident that Martin had, and that's it.
Yes, I see. The witness statement is with us in the court, Mr. AlHaj. Well, Mr. Bohar, thank you very much for now. Mr. Bohar, thank you very much. You may leave the witness. You may sit down. Thanks for your collaboration. Yes, Mr. Russell, who is your witness?
Well, my witness is the defendant himself. However, I would like to raise again the fact that there is no proof at this point, and that the burden of proof lies with the claimant. And I need to make a defense at this point. I feel that the court has already have everything to dismiss this case, because the claimant does not discharge himself from his burden of proof.
You can't ask me this question. It's whatever you want. The choice you make.
Well, I'm putting
me.
again my application for dismissal at this point. Then afterward.
And I replied to that earlier. I didn't have to repeat myself.
Oh, I understand. Okay, so I'll call my witness. And
yeah, if you call your witness, Mr. AlHaj will be reminded to ask him about his statement. Mr. AlHaj, if sorry, Mr. Russell, do you want to take a break before you bring your witness, or you can bring him now?
I would bring him now if you wish, because we're on a roll, and I won't be long with him. I don't know if Mr. AlHaj will be long.
Well, Mr. AlHaj can ask any question about the witness statement. Do you have his defendant witness statement, Mr. AlHaj, before you?
Yes. Yes, the last one, right? Yes.
There's only one.
It's the only one, yes, it's only one.
Yes, I will take that.
So now we're calling the witness, and you can ask him questions. Again, I will allow you to ask anything about written statement. Any question out of it, not related to the price of the shares, would be rejected. You okay?
I'm sorry?
I said your question must be related to what he has written in his statement.
Okay.
Okay, and about the sale of shares.
And just about the sale of shares?
Yes.
Yes, okay.
And the price or what's so on related to. Yes, Mr. Hussain, you may call your witness.
Sultan Khalifa Sultan Al Nehayan. I swear by Almighty God that the evidence that I am about to give is the truth, the whole truth, and nothing but the truth.
Remind me, where can I find the statement?
Tab
of your
18.
witness?
Tab 18, Your Excellency.
Tab 18. Yes, Mr. AlHaj, the witness statement of the defendant behind tab 18, and I hope it's before you. You feel it? Okay, and then, okay. My question to the defendant. Sheik Sultan, is this your witness statement? It's behind tab 18. You see it?
Yes, sir.
Is this your witness statement?
Yes, Your Excellency.
The signature on the second page is your signature?
Yes, Your Excellency.
Is there anything you would like to add or change?
No, Your Excellency.
Yes, Mr. AlHaj.
Yes. First, I will start with the point number 1. He said at the beginning of 2013, Mohammad AlHaj convinced me to come involved in gold holding. Actually, we started before that, before the idea
No.
of holding.
I didn't need a statement. I need a question. What is the question?
He said that the important one that I convinced him, so that's not true. I didn't convince him. You know, that both of us, we got into a mutual agreement.
Is it?
And he says importantly,
The question is that this is not true, and you have not convinced him. Mr. AlHaj?
yes. So on what basis did he say I convinced him?
And you saying how he come to you? How he approached you?
No, it came as a mutual project. It's not about...
Yes. How he approached you? That's what I'm saying.
How did he approach me?
Yeah.
He was my brother.
I think Mr. Abu AlHaj has no question here.
It's very simple, Mr. Sheikh can answer it. He said he did not convince you. Is that true?
No, he did convince me, and
That's it. Next question, Mr. AlHaj.
And point 2, he said that he shared that no amount of money were dispersed or were to be dispersed by me at any time. So, saying that, then you received it as what in terms of trading or exchanging shares in this group.
So this regards of point number 3?
2. So he said that he received these shares at no amount of money were dispersed by me or were to be dispersed by me at
and
any
now,
time.
what is your question?
So my question is that then he received those shares
For what?
for what?
Yeah, for what you received the shares, yeah.
Yeah, based on the trade of shares in the trade.
What's the consideration for receiving this?
Your Excellency, the shares were given to me in 2 parts. First part was a part of convincing me to join. Second part, we can refer back to it, to our memorandum of understanding, which was signed by both of us.
You hear that, Mr. AlHaj?
Yes.
Yes.
But still, I didn't get the right answer of these based on what.
Is it based on a memorandum of understanding?
Okay, has he completed any of those things that he shall have given as an exchange?
Have you completed the task that's given to you through the memorandum of understanding? Why you object?
I object because it's not an issue in the case. The case does not relate to the fact that support was given or not. The case relates to either it's a sale or it's the memorandum according to this agreement. To go to see if he did support the company or not is not an issue. It's not raised.
I will allow the question. I will allow the question. Have you did what you have to do through the memorandum of understanding?
Yes, Your Excellency, I did become a part of the company, chairman, and I was fulfilling every part that has been signed by the memorandum of understanding, starting from my involvement in the company, introducing, and all the obligations that has been stated in the actual memorandum of understanding.
AlHaj.
No, the question was...
He said he has fulfilled his obligation.
No, he has not done any of the obligation of the contract.
Well, I see your statement, but I see his answer as well. Well,
His answer that he did them all?
yes.
Okay, so let's start by the first one. What did he help in doing the IPO of Gold Holding? And the other point, how much he raised as he promised money? And the third point, how did he protect the company? And let's hear how we did.
Part of the claim
Yes,
of claimant.
I agree. Another question, Mr. AlHaj. Yeah, it's not in your defense, not your statement also, Mr. AlHaj.
Sorry?
It's not in your defense, it's not in your statement of a claim. It's not in the witness's statement as well.
Well,
Go on,
I'm saying right now.
go on about the price, if you would like to ask him about the price, about the consideration, about another issue.
Yeah, my point that if he did not implement, as he's referring to the MOU for those shares, as he's not...
No, I would like you to stick to your... I would like you to stick to your first point, is that the shares has a price. You want to ask him anything about the price?
Yes, like, and he says that those shares, they have no value for them. There's no exchange for them. He's saying the exchange is the MOU, and even though if you go to the MOU, he didn't fulfill any of the obligations there.
He said the shares got no values? Where is that?
The share has a value of $1 value.
No, but...
In the share resolution.
No, he said the shares got no value.
He said the shares has no value?
Come on, you ask me the same question I'm asking you. That your statement, you just said, the defendant said the shares got no values. I'm asking you, where he said the shares got no values?
No, the share has one value. It has one value, $1 a share.
Okay,
and
now what?
He's the one who structured the company. He signed with the officers of the company.
Then
so he knows that the share is $1.
Please, beg my pardon. Would you please ask the question again?
My question is that he says that he received these shares and no amounts of money were disbursed. So I'm saying, if he's saying that, if this is a trade of shares, there should be something in exchange. So he's referring to the MOU. I'm saying he did not fulfill any of the points in the MOU. So for that reason, he didn't fulfill the shares. The shares value is $1
I know. This is Mr. AlHaj. This is your point, and now what you want to ask. I know this is your point. I know. I've heard it. It's recorded already in the system. Now, what is the question to the witness? Witness is waiting your question. About the same point, you need to formulate a question to him.
I asked him the question. He responded that he fulfilled the obligations. I'm saying that he's not fulfilling, so I don't know what's the procedure.
So let me ask him on your behalf.
Okay, please.
Once the shares is transferred, and according to all of the negotiation, that you suppose not to pay him any cash money in return, apart from the management involvement of the company in your name. Is that right or wrong? There is no price apart from the involvement of your name and yourself.
Your Excellency, as it's stated in the Memorandum of Understanding, there is no obligation on my behalf to pay
Any cash.
cash apart from providing the services listed on the MOU. I have obliged to that as far as I'm aware.
Right? Okay. Yes, Mr. AlHaj. Another question?
No, he knows that he's taking shares and he has to pay for it. And he signed on the value of it for $1 a share. So now he's saying that he's buying something or taking something without paying. This is new for me.
Mr. AlHaj, write this note, and after the lunch break, you tell me whatever observation you have against the witness. Okay? This is a defensive point. I will hear it from you after lunch break. But now, please, just ask him. No. See, the witness evidence is before you. If you're not comfortable with any statement that's written, you might ask him about it.
Okay. Shall we do it after the break?
No. If you have a question, ask. If you didn't have a question, we will release we'll discharge the witness. Then you can defend yourself. Do you want to ask the witness any question for now? Because this is the only chance for you to cross-examine him.
I don't know what I'm supposed to ask him. What can I ask him?
And I cannot assist you more. And I cannot assist you more than this.
So shall we take a break and then I can ask him again?
No, but I can't wait. You can look at his witness statement now. I'm waiting with you. But don't be long.
He said, number 8. I received these shares at no amount of money were dispersed or were to be dispersed by me, and there has never been any other agreement nor obligation for myself to pay any amount whatsoever to AlHaj holding with any other person.
Yeah, he just confirmed this. Just 2 minutes ago, he confirmed it when I asked the question.
He said, frankly speaking, I don't know how to ask questions because I asked him and he told me it's wrong question. So
yeah, you might say it's wrong answer if you don't like it.
I can give an example, but please help me fixing my question if it was wrong.
Yeah, say what is the question now?
So, like in point 3, there has never been any agreement or obligation for myself to pay any amount whatsoever to AlHaj Holding Limited or any other person. This is not true. Because he was.
No. This is now as a. This is now this.
Otherwise, he would buy them from the treasury.
Okay, this is again. It's not a question. This is a statement. This is up to you. It's in regard of the burden of a proof.
My question. He's saying like, where those for gift or for other payments? No, there should be an exchange. It cannot be, you took something for free. So those shares, you have taken it for exchange. What is the exchange? If you are referring to the MOU,
yeah.
Please, I want to discuss with you. I want to ask you the points that are agreed in the MOU.
Maybe he can answer this, yes. You got the question?
Then, so my question, did he fulfill the points in the MOU?
Oh, he answered that question.
What was the answer?
Have you fulfilled your obligation toward the company?
Yes, Your Excellency.
He said yes. Well, he said, have you ever said it's a gift?
Was transferred with no financial obligation, and that has been stated again in the Memorandum of Understanding that we signed.
Yes, Mr. AlHaj.
In the last hearing, the defendant's lawyer said it was a gift.
Well, you can't ask him about, ask him about what he said. He's responsible for what he has submitted before us.
Okay, so my question is the same question. If he fulfilled, if he's referring the exchange for those shares.
So you want him to show you evidence, that's what you're saying. You want him to show you evidence. That's what you're trying to do.
No, I'm asking him if he did fulfill or not fulfill. Yes or no?
Said yes.
He fulfilled. Please, I want to note that down.
He said yes, he has fulfilled his obligation, Mr. AlHaj.
Okay. Then you might, because looking at the MOU, I actually started possibly, but I've seen it before. He has not fulfilled any of the points there. So I can start with the point number 1, and I can ask him.
Not in the case.
Yes, that will go in the deep detail of the management of the company, which not our point, Mr. AlHaj, in this case.
Res judicata on that point. It's been decided by the court.
No, nothing management to the company. It was an agreement between me, the AlHaj.
I agree. No, I see your point, but that point is decided by another judge, which you did not appeal.
For me, I want you to note down that he said yes, he has fulfilled the MOU.
This is recorded.
Yeah, I have no other questions.
Well, thanks. Mr. Rosen, do you have anything to do with the witness? Yeah.
I would request, Your Honor, if you can ask on my behalf, that would be appreciated. But you should take into consideration I have no lawyer, so you can help me on this. I know at the end you will be just, but I don't have any legal assets. So for questioning the defendant, I had only this question, and I want to note it down.
Well, thanks for your trust, Mr. AlHaj. Let's thank you very much. The witness may leave the books.
Thanks, Your Honor.
Thank you.
Yes. Now we have done with the witnesses. I'm asking both parties whether do you want to do like the closing submission orally, or you would like to write it down to the court, or Mr. Rosen, you will finish orally. Mr. AlHaj, do you want to say your final submission orally after or before Mr. Rosen, or
I would say after.
or do you want to take a break and write your note and then say them to the court? Do you want to comment on what the witnesses has said?
Okay.
Can we take a break of 1 hour, then we come back for oral submission?
Okay. Okay.
And then, Mr. AlHaj, I will remind you, you can say anything about evidence, about law, about fact, your final statement.
I'm serious. I'm very confused with the incident of Martin, because now he left. I don't know where is he, and he went to the country. He has been threatened, and he was kidnapped. The defendant came with a few bodyguards, with CID, and just to show his power in the court of DIC. This is what I was surprised of. This is not nice for the DIC court. And threaten him, making him not to think, making me not to think. I don't know what to ask. When my witness is being threatened in the court itself, this is not good for the court.
Oh no, your witness is safe. Your witness is safe and breathing, and I can see him.
Where is he? Before he came to this
Mr. AlHaj, he is in front of me. Mr. AlHaj, he is in front of me.
Yes, I know, but he was harassed outside, so I really need the court to take this notice. That, because something wrong happened, that's something bad. He's not just helping me in this case. He's helping like 3,000 people, innocent people. All of their assets have been taken, and he's representing all of them. He promised all of them to give them right.
The court do not act without application, Mr. AlHaj.
Yes.
Okay.
This notice that he was harassed during the.
Yeah, we recorded what you ever said. Okay, Mr. AlHaj, we'll break now. We'll hear from you after 1 hour.
Okay.
We will come 2 o'clock sharp.
Okay, you will call me back, Your Honor?
Oh, I suppose you call back at 2 o'clock.
Okay, I can call back.
1 hour is enough for you.
Okay.
So be prepared for this 1 hour. It might be the last chance you speak to court. In this case, in this application.
Well, you're the judge.
Try your best, Mr. AlHaj. Thank you very much.
All rise.
That's right.
supposed to be.
We are not concerned that does not facts that are not really.
Good afternoon, all.
But,
Are you with us, Mr. AlHaj?
yes, I'm here.
Okay, great. I hope you had enough time to prepare yourself
Yes.
for a closing submission. We're ready to hear you if you're ready.
Okay, so as I have understood, Your Honor, this is my final statement.
Right.
So I don't know how you consider it, take it as my witness statement, but this is my final
No,
statement.
it's not witness. It's not witness. This is not evidence. You need to take me through the evidence, the fact. You need to make things clear for me. You need to comment like on the evidence that's been heard today. You need to refer to anything, and then you need to put things together, you know.
I just wrote a
Yeah.
statement, and if you can help me, if you need more information, I can emphasize on that.
No, I only can hear you. I can't help you. I want to hear you only, and then I'm recording whatever you say, and then once you're done, I will allow your opponent to start his
Okay.
closing submission. Please go ahead.
Okay, I just wrote it and I will read it. First of all, I thank the court and Your Honor for letting me and being patient with me. First, I said this before, but I have requested from the court to help me find the legal assets, but unfortunately, whomever we approach, they decline us as a conflict of interest. I understand that getting involved in a case against a member of a family member could be risky, since it's probably one of the few cases in the UAE. The IFC court was structured on just and transparent. For that reason, I still seek just here in the IFC court. The only claim which the court is now looking at is the 10 million shares at a value of $10 million, and strike out the other claims which will seek out with other shareholders and another motion or requesting an appeal to amend the claims as advised by His Honor, the previous judge. The defendant said that in the last hearing that those shares were a gift after His Honor, the previous judge, said to him that each trade shall have an exchange for equivalent value. So his answer was a gift, and the judge asked him to prove for him as a gift, and we ended on that case. Now, I'm shocked where they came with this MOU. I know about this MOU. Actually, this is more evidence for me. So he said that it was a gift, and now he says it's based on the MOU. Regarding this MOU, yes, I confirmed this MOU when we did this transaction, because he promised to raise over $100 million, and this is an integrated agreement. What his obligations are beside that agreement, because he's taking shares of Class A. So those shares have an obligation. So this MOU only means about that the objectives of taking such shares there, where he controls the power of the company. And so the president even respected the MOU and all of its terms. And first, his action after having the Class A shares. So the first action after he took the Class A shares was to fire whom he took the shares from, whom has fired him. After that, with his the office managers, whom are his witnesses, all assets of the company and its clients' investors have been taken by them, whom are in jail right now. Another very main point I would like Your Honor to acknowledge.
Yes.
On the case number 11, 2016, the defendant claimed that he lost investments of $10 million and he wants them back with damages. He's requesting that from us, from AlHaj Holding. So for this, it means that he's claiming his investment of $10 million. So he's admitting once again now that as if he paid his money. So he wants it back with damages. I hope the court acknowledges that the defendant is not saying the truth.
Yeah, but this is not this is what you say is not before me, Mr. AlHaj.
It was a gift. Yes.
Yeah, I cannot see what you're referring to. CFI 11 is not before me.
Sorry?
Case number CFI 11 2016 is not before me, so I cannot see how the claim is based.
It's just new, and I just got to know about it a few days ago. where he says that he wants his $10 million back plus the damages of them. So this case is in DIC. It's not against me, and against the witnesses, against the 10 people who were working in the company.
And you saying that means what?
It's saying that he wants his $10 million.
Yeah. And that, what does that mean for you?
That means that, he's consistent of lying and not saying the truth, because once he said a gift, there's a big difference. If someone gave me a gift, and next day he tells me, oh, well, I lost this, I need them back, so that's not a gift. And then he's saying, okay, this is regarding the MOU, even though the MOU has no relation with this transaction. I would like to continue my statement, Your Honor.
Yes, go on. Yes.
So for me, by saying that the defendant's first saying it's a gift, and then saying it has a different regarding the MOU. So for me, that's changing. And then with the new case, it becomes very obvious. People can see that he acknowledges the value of the shares that he took for $10 million. Though the auditor, Martin Booker, whom assigned by the defendant, also confirmed that with his statement. Also, another point, the defense said that AlHaj is a major shareholder of the company. AlHaj is not a major shareholder of the company. Otherwise, I would not be fired from the company if I was a major shareholder of the company after he took the shares. When he said that there was a stock option cancelled in the MOU, the contract shows that the value on that contract was $0.50, which means that the shares payment is required and it has a value. So how come in that contract it has a value of $0.50 and the word payment is there, and then in this contract it has the value of $1? So when he's saying that the value has no
What contract you're referring to?
The defendant referred today in the MOU, he said at the last, that the last paragraph says that this contract cancelled all other contracts before.
Yes.
Which is a stock option. So this stock option that he referred to, okay, it was also an agreement for buying shares of the same company, same number of shares, everything, and it was a share purchase stock option agreement, and it had a value of $0.50. And then we got a bigger contract, and the value got bigger more, so it became $1. But he had to, and he wanted to have it an A share, so he had these other obligations that are in the MOU. So the MOU is just to define the obligation on the transfer of shares resolution. So my point is that he said that AlHaj is a major shareholder. I'm not a major shareholder, otherwise I would not be fired. When he said that he had a stock option cancelled, this is I pointed out this, the company had a big value until he took the management. 9 months after, it had no value. So this is what the fact. Finally, I'd like the court to consider my ignorance in legal procedures and legal terms and not to judge on me based on any non-performing from my side. For me, law is like medicine. I cannot prescribe medicine, but I can describe the pain. The bottom line is, His Honor, the previous judge said, for each business transaction, party has to exchange equivalent value. We see that in the resolution that we have submitted, where it says the quantity and the price for this transfer. Those shares were not a gift. They were worth $10 million, as the defendant mentioned and signed. And as the articles he approved. And also as the court acknowledged the fact that when we foreigners deal with a member, with a willing family, is different than others. I would like the court to take that into consideration. And I never heard that a sheikh from the willing family takes shares as a gift and never fulfill his obligations to him. By the name of just, actually by the name of the just, I request him to pay me the value of the shares transferred to him from my company. The court sees the quantity of the shares, the price of the shares, and his signatures for this transaction. And thank you very much.
Well, thank you, Mr. AlHaj. We now invite the defendant. Lima, if you may move the microphone, at least in the middle, so he can hear.
Like it was mentioned previous hearings, this case is quite straightforward. It's claimant claims he's owed $10 million for a transfer of shares. Basically, in contract law, you have to prove the agreement. D24 is the agreement that was proved. Claimant or its representative, Mr. Abu, that D24 exists. Now he's trying to say that over and above this contract, which provides for no amounts whatsoever to be now owed another 10 millions over and above the support and over and above the defendant had to do. So you've got one witness coming up front to you, which is the defendant, and I'll cross over right away to the burden of proof. Defendant comes forward with an agreement that shows exactly what happened between the parties. Technically, his burden of proof is not on him. It's on the claimant to prove the existence of the agreement, not on the defendant. But in any event, we provided D24. It was shown by different documents, at least the share certificate, that the shares were transferred. There's no proof whatsoever of any claim of money. There's a corporate resolution that does not refer to any amounts payable, and it's normal because it's a share certificate that, and on one hand, and a corporate resolution from Gold Holding, which only is looking at the transfer itself. It's not regarding the deal that was made between the parties. The deal between the parties is between AlHaj Holding and the defendant. Now, if I may refer right away, the AlHaj just referred to gifts and having given. If you refer to paragraph 5 of our initial defense, this is where you will find our statement at start regarding our defense in this matter. 5, which was pertaining to...
Behind tab?
It's in tab 11. In tab 10, sorry about this. Tab 11 is the amended one. Go to paragraph 5, page 2, which is page 133.
Yes.
Trial binder.
I'm in there already. Yeah.
You will see at the end of the paragraph, now belonging to the defendant, have been issued by Gold Holding and are fully paid and completely released. In Gold Holding books, the shares are fully paid and released, because there's no cash call on these shares. They're released to the defendant without any restriction whatsoever. No, and then we continue in our defense. No amounts, of whatever nature, are owed to either claimant 1 or 2. So, at start, we issued this. Furthermore, if you look at paragraph 14, plea, and you will find this same paragraph 5, which will now be in the amended defense, is still there. But if you go to 14, page 133, at the bottom of the page, at the beginning of 2013, Mohammad Abu AlHaj convinced Sheik Sultan to become chairman of Gold Holding, and at the time, a company to be formed. Excellency Sheik Sultan Khalifa was to receive 1 million shares for his involvement by providing his name and contacts to further help financing and develop Gold Holding. Never mentioned by us, and I don't know where Mr. Abu AlHaj is taking this, that it was a gift. Always been an exchange of consideration between the parties. Paragraph 7, you will find the same paragraph as you have the other one as paragraph 5. And if you go to paragraph 53, have the same allegation. Because you have to understand, Your Excellency, that at the time of filing the first defense, everybody was looking for
Paragraph 30?
53, 53A, which is on page 157 of the trial bundle.
Yes, yes.
It starts at 53A, and then it refers to D24, which amounts to the end at paragraph 54 of who is shareholder, the shareholders of Gold Holding. And this was issued by the official person that's taking care of the shareholders register. So it was at all time identified as being for the transfer of shares. Always the same between the parties. Now, if we look into the agreement, on one hand, you have one witness, that's the defendant, coming forward and testifying to the court that to his knowledge, he respected everything that he was supposed to do. Have no proof on the other side of the room. Now, if I look into Mr. Bouher's testimony, technically he doesn't represent Abu AlHaj. He's not aware of any concern regarding the business of Abu AlHaj Holding. No knowledge except of having seen in the past this agreement. Now, there's three elements in a contract: an agreement, a contractual intention, and consideration. I think I've covered both. Consideration is the support. The agreement is well described by the parties, at least by the defendant, which was not his burden of proof. But anyway, in some jurisprudence, there is an allegation. You will find in some jurisprudence that I've provided the court. It says that sometimes when out of normal course of business, the burden of proof may shift from claimant to defendant. However, defendant has charged his burden of proof and has provided the court with the exact agreement that was agreed between the parties. Now, the shares were transferred. Registration was made at the IFC. Mr. Abu AlHaj confirmed that. The corporate resolution was passed in Gold Holding. The defendant acted on the agreement. Mr. Abu AlHaj may not agree with it, but that's the proof that the tribunal or the court has before it. The MOU does not provide for any future contract to be signed. In fact, it annuls all previous contracts that may have been. And it does not, certainly not provide for a future payment also. Now, as for consideration, there is also more than support. Support is one element was constituted. However, there is also binding obligations regarding non-compete, regarding confidentiality and disposal of the shares. So this is a full agreement that doesn't need any other or additional proof regarding it. There's no missing elements in it. So basically, I want to keep it simple because it is simple. Claimant does not discharge his burden of proof. Claimant, on the other hand, did provide for the proof of an agreement between the parties. Respectfully submit that this case should. Cost, I have prepared a statement of cost for the tribunal, so that you have an idea. If I may, I can produce it to you. set in for the trial. Preparation of trial and hearing will be shorter than expected. But however, preparation was quite long because at this point, I want to make some kind of representation that on one hand, AlHaj was even without respecting any rules, without providing any document, still wanted to go to trial. So we had to prepare just like if it was a regular trial with people coming in to testify and so on. Up to last week, we could have received. Had to prepare for all kinds of situations where, because we didn't have any skeletons. So basically what I want, and also as was mentioned by the court, and it was an order. By legal work to some extent. So, but basically, in light of this case, it could not be referred to a junior or $10 million case. That has trials. At start, it was a $360 million. Still down to 10 million, but still, for most of us, $10 million US dollars.
Thank you very much, Mr. Hassan. Yes, Mr. AlHaj. Mr. AlHaj?
Yes.
Are you, do you hear me? Yeah. Well, I think we came into the end of this trial today. I think I've heard enough from both parties. Unless there is anything very serious and urgent you want to tell me about.
Regarding the gift issue, I remember that we talked almost 20 minutes about it with the previous judge.
Right.
So I don't know why he's denying that. So if we can go to the hearing, we will have it if he still denies it. On the other hand, regarding the funder and what he has submitted, that's something he did. I hope he, because I don't have it. Okay, I took everything in a good faith. So he told me that I couldn't email it to you, so I have it for you in the court. So it's not in front of you. And so I have to pull up the document from here and there, and I don't know if he did that on purpose or not.
It's okay.
I'm finished. I put my case, and I think I said everything I have said.
Okay, well, thank you. What I remind you now, we cannot accept any, you didn't send any document or any submission. So the court would reserve this case for judgment. I'm not anticipating when, but it might be shortly. Like it's more probably in January, the judgment. But I said we are closing everything. You cannot send any document or any submission anymore, Mr. AlHaj.
Okay, and
yes. We will inform you once the judgment is ready. We will inform you.
Okay, and regarding my statement that I said it will be documented, right?
Everything documented, yes.
Okay.
Yes, it's recorded, and then we have a transcript as well.
Is Martin still in the court hall?
No, I don't see him. No one. It's only the defendant, lawyer.
Oh, because Martin, I don't know where is he, and I would like to note that after this hearing, I cannot escape him anyway from what happened. I don't know. Okay, so.
Well, maybe one more observation from.
Just one more observation. Paragraph 21.
Bara 31?
21
21.
of the order of February.
Thank you. Well, thank you all. Thanks for your collaboration.
Okay. Thank you very
So,
much.
yes, case is reserved for judgment and cost. Thank you very much.
All rise.
Thank you. Thank you.